I'm Nick Singer, and this is Jamie Fireman. We're employment practitioners here at 42BR Barristers. This is the second session in our current webinar law series. Previous recordings from January to July can be found on the website. Just so you know, any questions that you have can go into the Q&A box, and that'll be addressed at the end of the session if we have time, or also might be followed up by email. Perhaps if we're feeling particularly spontaneous, maybe we'll do it at the time as well. And if you're watching the recording afterwards, please send your questions to events@42br.com. So the talk we're doing today is entitled Trial and No Errors, Top Tips for Helping Your Barrister and Clients Succeed at Tribunal. This may or may not have been created by an AI. You'll just have to figure out how creative you think Jamie and I are. What we're basically going to be doing today is taking you through the life of an employment tribunal claim at each stage and giving you tips. So Jamie will be representing the claimant, I will be representing the respondent, and what we're going to try to do as much as possible as well is sort of focus on the trial. So it's about allowing, sort of seeing how you can help us to be the best advocates we can, but we're also going to think about judges and what judges might think, and really trying to focus on how best to prepare and get inside their minds. Obligatory warning. Please do not rely on this as legal advice, and also an email containing the recording and a feedback form will be circulated over the next few days. So let's get into it. Jamie, we're going to look firstly at pleadings. So do you have any tips for a claimant on how to plead their claim?
Yes, I do. And
that's good.
Yes, exactly. And the pleading obviously is the ET1, the claim form, and any attachment to that, such as the particulars of claim or grounds of complaint, however it's characterised. It is the starting point for a claim, and it's undoubtedly of vital importance and needs to set out clearly and concisely the basis for the claims that are pursued. I like this particular quote from Chandok and Turkey, which says this. It says, the claim as set out in the ET1 is not something just to set the ball rolling as an initial document necessary to comply with time limits, but which is otherwise free to be augmented by whatever the parties choose to add or subtract merely upon their say-so. Instead, it serves not only a useful but a necessary function. It sets out the essential case. It is that to which a respondent is required to respond. So two things arise from this. The first is that the grounds of complaint should be approached really with the intention that they include the entirety of the claims that are being pursued, rather than relying on the opportunity to potentially add or amend the claim later down the line in an ideal world.
Yeah.
Obviously, we know that amendments do occur, but that should be the way in which you approach it, because that will avoid relying on an amendment application which may fail or be costly in any event, even if it succeeds. The second thing is that if you do put something in your pleading, you should be confident that it is accurate and that it reflects the case that's being pursued, because there are significant consequences, particularly for a claimant, and their credibility in trying to remove or resile from something that's been in their claim form.
Yeah, so I suppose that sort of difficult balancing act about what you put in, but I you don't want to be amending later. So practically, how do you approach that balancing act?
So from the perspective of the claimant, strictly speaking, the ET1 requires you to tick the relevant boxes in Section 8 of the claim form to indicate which types of claim you're pursuing. So in an ideal world, these boxes have been ticked. You've indicated if you're pursuing an unfair dismissal, discrimination claim, or an arrears of pay claim, or a combination of all of these types of claims. And then you've got an additional document or a narrative that sets out the basis for the claim. And that narrative, that particulars of claim or grounds of complaint document should be setting out the precise complaints that are being pursued and how, in each case, the integral part of those claims are made out. And so this would include, so I think it's probably easier to take an example. So imagining you are pursuing a claim under Section 15 of the Equality Act, discrimination because of something arising from disability. You need to set out, first of all, that the claimant has a disability and the nature of that disability. Presuming that it doesn't fall into one of the prescribed conditions, such as, say, cancer, which automatically amounts to a disability, you should set out why you meet the definition in Section 6, why it has a substantial and long-term adverse effect, how that impacts the claimant on a day-to-day basis. In short, you don't need to go into the same sort of detail you may see in an impact statement, but you should set that out. Then why it is contended the respondent knew about that, what the unfavourable treatment was, what arises from the claimant's disability, so how it manifests, and then why it's contended that the unfavourable treatment occurred because of that thing arising from the claimant's disability. And the benefit of doing it this way, setting out in that sort of formulaic manner, is that it means that you are in a position to frame the list of issues that will then ultimately come to be agreed. And the list of issues is and has been described as a roadmap by which the judge is to navigate his or her way to a just determination of the case. That's the Zippy Stitch Limited case, and that's a perfect characterization of its role. And we know from the recent case of Moustache that the Court of Appeals made it very clear that an agreed list of issues is an express agreement that the tribunal should conduct the proceedings in a particular way, and the tribunal will usually be entitled to confine its investigation to that list. So the list is really important. If you've set things out in a very neat way, in a very coherent way in the pleading, you're then allowing yourself to get the list in good shape that will then be relied on by the judge to navigate their way to a just outcome, as it's put. Now, but before we just move on from pleadings from the perspective of the claimant, there is one warning that I think is worth giving to claimants. Is this: pleadings aren't witness statements. And you don't need an excessive background necessarily. You often don't need an excessive background. There's the case of C&D, which puts it nicely, and it says that, parties and representatives can remember the purpose of the claim form and response is not to exhaustively set out factual detail in the way a witness statement does, but just set out the claim. So what the claim is, and the reasons you don't want excessive detail, that there are actually a lot of dangers in having too much detail. You need what I said before, the formula that's going to get you to explain why the claim is made out. But if you have too much detail, there are a number of issues you can fall into. So first of all, as you said at the beginning, looking at this from a judge's perspective, you're making the judge's job harder. You're giving them more to read, and some of it may not be relevant. So fundamentally, you want the judge on side. And if you're being unnecessarily verbose, you might frustrate a judge. That's just a simple point. Often it can muddy the water as to what your complaints actually are. If there's an excessive list, it might lead to sort of a credible suggestion from a claimant's perspective that you're in fact just complaining about everything, and the claimant is someone who's prepared to do that. And it also just provides an opportunity to trip yourself up from the claimant's perspective that you don't need. Keep things to what's essential, and you don't have that at risk. It can also increase the cost involved in the proceedings because there's more to respond to, and should a claimant be unlucky enough to fall foul of a costs order, they won't be able to say, well, that wasn't proportionate, because they've given a huge amount of narrative to respond to.
And I think it's important to look at it again from the perspective of a judge. So I had a case the other day where the judge was confronted with a 60-page witness statement. Now, I know we're talking about pleadings, but the broad point the judge was making was, even just the length of it in and of itself was sort of enough for them to start with the sort of, and it's just not a good start when a judge is already frustrated. Now, a witness statement might be a bit longer, but this is especially true of a pleading. Just how excellent a pleading, if it can be short and punchy, and the judge can look at it in 10 minutes, 5 minutes, and get the claimant's case. I think it can make such a difference. It's the first document a judge is going to read in the entire case, pretty much. So it's what a great opportunity to get them on board. Absolutely.
I mean, there is, I think, an important caveat to this, and that is to say that's not always going to be. It's not always going to be possible to keep things completely short, or and as concise as we might want. There's the case of Tarn and Hughes, which I think was in the context of indirect discrimination. I need to check that, but I think in any event, what the point that's being made is that in discrimination cases, it won't always be possible to keep things as succinct as may otherwise be the case. The ET needs to consider the complete picture. It was said there. So that means that it might be tempting. They say it's tempting to say pick its best 10 points. But in a case which has multiple different elements to it, you might need to give that context and set out all of the different elements. That's the case in certain discrimination cases, but it won't often be the case.
And it's not easy, isn't it? There's always that anxiety. What if I leave something out? What if one of those tricky barristers who we don't like very much, say, well, in cross-examination, well, you say that in your statement, but you don't say that in your claim form. I mean, my experience is judges aren't all that receptive to those points. I suppose it depends on the case, but if it's a respondent witness, I often find they'll say to a respondent witness slightly different, but well, they didn't write the response. Did they move on? I don't know whether for claimants it is, but I think if there's any issue, you can wave C and D in the judge's face and say, remember, we're not supposed to be creating a witness statement. And I don't think those points are particularly well felt in the tribunal.
I was going to say, I think that's actually a point that might go down better in civil litigation than it does in the employment tribunal.
So how do we do this? How do we, as a claimant, achieve this?
In relatively straightforward terms, there are sort of a few important factors that can assist in getting us to that stage. The first is obviously to take very clear, precise instructions, detailed, and understand the essential ingredients of the claimant's case. So clarify those with the client, make sure that any documents that are being relied on or cited within the ET1 and the pleading have actually been reviewed independently of what the client says, because then that narrows things down, that clarifies any ambiguities that may later come up. You've had those discussions with the client early by comparing what they say with what the contemporaneous documents say, and that then leads to sort of the third part of that, which is to then challenge the client really on the substance of what is their case actually about. Often lay clients, for obviously understandable reasons, have a lot of concerns. Not all of those concerns are claims. So it's about working out what the substance of their case is and what the claims that arise from that are by having a good initial conference with the client, really. And that's the best way to do it from the claimant's perspective. What about from the respondents?
Well, I think one of the most important things to think about as a respondent, I suppose for a claimant too, but as a respondent, let's think narrative. What is the story you're trying to tell? Now, I'm not naive. I do understand that a lot of our clients have mountains and mountains of cases, hundreds sometimes, and you can't always sit down. You need to get the facts out, bang, bang, bang. I do understand that. But if you are able to take a step back and just think, can I distill the case in my own mind into a paragraph? Just, what are we trying to show here? Is this a sad situation, but we had no choice? Was this person a nightmare person to deal with? And I think it's really, really important. I'm going to actually drop in a little bit of psychology here that I read about. There was a psychological experiment. They had an individual doing a speech, and one side of the hall had a very negative biography, and the other side of the hall had a very positive biography. And perhaps as no one's surprised, the side of the hall that had the negative biography, they all had the same speech, but with the negative biography, they didn't really like the speech all that much. With the positive biography, they really liked it. So it just goes to show you, if you can get that story into the judge's mind from the very beginning, I suppose this applies to a claimant too, the way they see the facts later will always look different. You need exactly the same fact, but in two different ways. So again, it's your first opportunity as a respondent to put that in. Secondly, in a grounds of resistance, can you make some sensible concessions? So the classic one, a protected act, they're usually not that complicated. They can be, but usually not. Can you just concede the protected act? Make the respondent seem sensible, make the judge think, great, that's one thing I don't have to worry about. Is it really worth contesting a PCP? Exactly the same point. Getting issues like legitimate aims sorted out as early as possible. Of course, we do see the boilerplate ones, and then you deal with it at the first PH. But again, it just looks so good presentationally. If you want to look like a professional respondent, you've conceded this, you've conceded that. This is all clarified at the first PH, straight to case management. It just looks really, really good.
And what do you think about with legitimate aims? Do you think that you should try to identify exactly the precise legitimate aims that you're relying on? Would you favour an approach which says here are a number of different legitimate aims which we may later rely upon, or does it really just depend on the circumstances?
Yeah, as ever, I mean, these things always depend on the circumstances, but I think less is more. It goes with the theme, why plead 8 legitimate aims when you can plead 2? So I think conciseness always better for a respondent, in the same way as for a claimant. Then you've got these other issues, things like chagga, polky, contributory fault. Again, we often see boilerplate pleadings about all of these issues, which again, I do understand, but can you actually put a bit of early thought and say, well, what's my case here? Put some thought in, plead something specifically. It helps, because then what can often happen is you get to trial, and whilst the tribunal always has to look at these things, and it's sometimes very obvious, you don't want to take a claimant by surprise and be like, well, I didn't really understand you were running that specific case, and that can lead to complications or adjournments later. But also you're letting the judge know from a very early stage what to look out for. So I think, you need to think, for example, there might be a case to say, well, they were going to be dismissed in any event, because on any version of events, there was going to be a final written warning, and they had all these problems before, and they're going to be out. I do appreciate that can also lead to the issue of, oh, well, they wanted me out. It just depends on the fact, but I think a little bit of thought at this stage can save a lot of time later and really focus the mind.
Yes.
And a couple of other tips, I think, as a respondent, it's always a good idea to speak directly to the relevant parties. Sometimes you can get a bit too much information third hand, perhaps someone from HR, but you need to actually go to the people who were involved and get that information. Make sure you understand where your information is coming from, and also have a look at what are you not being shown. So, for example, you may have read about a document, but then you have to look at, is there another document within that document? Go to the original documents yourself. And finally, the question of requests for further information. So you've got a litigant in person on the other side. I think one of the main things you need to do is make sure you're not getting reams and reams of extra information. That's always the danger with the further and better particulars. You have this concise claim, and then suddenly you've got 40 pages that comes out of it.
And where do you stand on whether or not it's strategically advantageous for a respondent to request further and better particulars? I mean, it's something that you sometimes see as just a default position. Perhaps there may be strategic reasons for that in terms of giving the respondent more time to respond. But what's your view on that?
I think, again, as always, it does depend. But it's important to ask yourself, do I absolutely need this information? I mean, sometimes it's pretty obvious as to what the case is. You don't want to plead to claims that aren't there, but equally, you can end up in a situation where you ask for something, you get it, as I say, you get 40 pages, and then suddenly you've got an application to amend, and then suddenly you've got another day and all the costs. So sometimes you might just think, you know what, they put barely anything in the claim form. This is probably it. Just let sleeping dogs lie almost, and just plead a concise case, and then maybe you just can get that way through. Depends on the facts.
At least in the circumstance you're talking about, the case you're facing. It can only be contained within. It can only be what's contained within the claim form, and that's what you're responding to. Whereas, as you say, otherwise you run the risk of things potentially spiraling out of control.
Yeah. So again, you need to think about perhaps how you list these PHs. We've all been in PHs where you run out of time. So just think, do I need a slightly longer one? Okay, so if what we just said doesn't really work and you do need clarification, perhaps a slightly longer PH, increase from 2, 3, even a day, just get it all done. You're saving the client money in the long run, because you don't want to come back. And I have had cases where sometimes you've come back 3 times to plead the case, and it's not anyone's fault, but you started with 2 hours and maybe it should be a little bit longer. But I think a judge told me recently, they really don't like the further information route. You send a claimant away after a PH, and you get, and in this case law on that, you get 40 pages back. So if you can say to a judge, look, let's use our time wisely, because judges will just, I'm sure sometimes let's just put it off. Let's just put it off, and it just creates complications in the long run. So I think try and be forceful and pushy as possible to get the claimant tied down as early as possible.
That makes sense.
So that's pleadings. Another part pleadings, not really. I mean, it could be tied to it is schedules of loss and counter schedules. So let's start with schedules of loss. First question is, when do you think you should draft the schedule of loss?
Well, the short answer is usually it's something which gets ordered by the tribunal at the first preliminary hearing. But there is an advantage to drafting one, and at least a provisional one as early as possible, because once you get to the preliminary hearing, often what's happened is parties have become a bit more entrenched in their positions because time has passed, usually many months since the actual decision that's being complained about, whether that be a dismissal or otherwise. That's the reality. So there is a benefit in especially if you're representing a claimant in terms of managing expectations, getting a draft schedule in place as early as possible so we can see what the likely losses are. Of course, losses are continuing in many cases. But I think the early starting point can help because it can both manage expectations and can also ensure the evidence that you need is there. Obvious things like pay slips, any benefits that have been received, any pension information that's been lost out on, any medical evidence that might need to be relied on for the purposes of either proving disability or supporting, if you need to, a personal injury claim if that's being pursued. And also any mitigation documents, any information about a new job, for example, or if you're going to be saying something like there's a long period of loss that you need to justify, explaining why that the loss has in fact been mitigated insofar as is possible. And then also, if you can think about from the claimant's perspective, if you've got any information that you're going to need from the respondent, putting them on notice of that at an early stage, saying we want this information, usually pension, it's usually pension certainly you'll need that they hold. Yeah, exactly, spot on, Nick. Yeah, and that's just and if you can say that and cooperate with them at an early stage, then the information within the schedule of loss won't be a surprise to them.
Imagine agreeing a pension. Imagine how happy a judge is that the pension loss has been agreed.
Exactly, and then that goes back to your wider point about making the judge's job easier, giving you a better chance of success. I think you can. There are some possibilities to change it later, but it's not a document that you have completely free rein to just change. It can impact credibility if you start saying something at one point. You're saying that in fact your claim is worth, to take for example £100,000 as a figure plucked out of the air, and suddenly you're saying actually it's £1 million. It doesn't look great.
And what should go in it?
Well, fortunately, the presidential guidance sets out very helpfully the sort of typical things that will go in there for a lay representative or a lay client or a litigated person, or indeed just representatives. And it says, to just run through some of the examples, things like wages due, pay in lieu of notice, for example, if you're claiming for wrongful dismissal, outstanding holiday pay, a basic award, redundancy payments, those sorts of things, all loss of earnings figures, loss of pension, and then obviously with discrimination claims, you have things like injury to feelings award, what you're claiming for that. Aggravated or exemplary damages in circumstances where they may apply, although some people try and rely on them in any event. And then if you are pleading personal injury, separately damages for personal injury where you can actually show that the discrimination has caused the personal injury and you have actually suffered a recognised personal injury. It's not the same as just another injury to feelings award. So the important thing I'd say is, with the schedule of loss, you need to know the case, what the losses have actually been. And what I'd say is you want to make sure that the schedule of loss contains everything that the claimant is claiming for, but only everything they can claim for and not things that aren't permissible, because that's just going to wind up, again, the judge and the respondent and make either your job more difficult at tribunal, or they make it more difficult to potentially resolve the claim amicably through a settlement.
Yeah. And I suppose one of the really difficult questions is, how do you pitch it? And we've all seen those wildly exaggerated schedules. I mean, does this achieve anything?
But my view is there is, of course, like all of these things, some balance there. But I think that over exaggerated, if we can use that phrase, schedules are not often in the claimant's interest. It's important to manage the expectation of the claimant, and remember that actually it's better to be realistic and optimistic than exaggerated and unbelievable. And everyone has a different view as to what achieves the best success. But my view is work out the range of what's the realistic best case scenario, if we can say that, and then maybe go just above that point, and pitch it at the top of the or just above the realistic best case. And that way, the schedule looks as if it's credible, but also you're putting the client's case at its highest and giving them the best opportunity to succeed.
A bit more psychology here. I think there's a concept called tethering, something along those lines. And if you can tether a judge to a figure, they psychologically feel closer. But if it's so wildly out,
yes,
they just throw it away. I don't know what the analogy is, but they're out at sea. I don't know. But once you get so unrealistic, I say, well, they're not serious. I'll make my own mind up.
Your figures no longer have any value at that point, and it's that's the careful balance that we're trying to achieve. So it can obviously depend, though, to some extent on the timing of when you're doing this. What the aims of the client are. Is it their aim to settle at the highest possible figure? Are they trying to get the respondent to the table? And what are you doing? Are you dealing with some a respondent who just routinely doesn't settle claims? Are they a small company that you might be able to put some pressure on? What's the likely response going to be? But as we said before, these are documents that are going before the tribunal, and they're fair game to be assessed and looked at in terms of your credibility. So from a claimant's perspective, they do need to remember that it's not just a freestanding opportunity to just have a go. Ultimately, though, from the claimant's perspective and from a representative perspective, it's worth speaking to the claimant to get a sense of what they think that the financial realities of the respondent are, so they can think about actually how do we think a respondent's going to respond to this schedule of loss, and that can then help to influence the approach you take.
And of course, the personalities that are involved as well. Like if a claimant knows, well, it's a small company, the director is an absolute, very, I'm not going to settle anything.
Yeah.
It's like, you use the claimant's insights into pitching it, because they know the company where maybe they've been dismissed from, and I say they don't want to wind anybody up.
Well, exactly. And I think thinking about how do we pitch these things? It's tactical, isn't it? Really, the telling the client certain things, like the basic award, for example, it's easy. There's a formula for that. Obviously, there are some unique circumstances. For example, if a claimant might be seeking reinstatement or re-engagement, then you need to think about how you're approaching that particular issue, because the respondent will want to know early, I think, that's the case, so that they can factor that in. And often it can prove to be a deal breaker for settlement, in my experience.
Yeah, or it can put pressure on a respondent as well. Reinstatement or re-engagement can be a real potential issue. Obviously, all the extra damages involved. So think about it. Genuinely got to be careful, I think, to do things for tactical reasons, but reinstatement re-engagement can be a useful tool.
But I think it goes back again with the schedules to your point at the beginning of the talk about the narrative, because you can use the schedule to try and tell the story that the claimant wants to tell. Mm-hmm. It's not the same as a witness statement, but it can frame things in a way that is easy for the respondent and the judge to understand, and it can encourage, as you say, it can encourage a respondent to settle if it's realistic and contains only the information that's necessary and contains only the claims that you're pursuing, and doesn't try and include other things additional. And it also tells the judge a story of what you want. I think that's where you have the opportunity, where it leads on to sort of thinking about do we need to explain the schedule at all. So sometimes if you are claiming a particularly long period of loss of earnings and it's justified, then think about, can we explain why? Can we put a bit of narrative as to explaining why we're claiming such a long period? Because as we were talking about earlier, you can have an initial response to a schedule. You see a particularly high figure, it can put a judge off or a respondent off. But if you explain it coherently, so actually there's a reason I've got 3 years of loss of earnings here. My claim is a discrimination claim, and I've had these medical issues that have stopped me from going back to work. Then that can help to tell the story. So, but those are the sorts of things that are important when thinking about a schedule of loss. What about a counter schedule, Nick?
So I'm going to assume you've got lawyers on the other side, at least to start with. And I suppose the question with the counter schedule, again, going back to the fact you've got a lot of cases, and sometimes is it worth doing one at all? And so they're not routinely done, and they're not routinely ordered either. And it just depends on the facts. And it depends on your client. I know clients are cost conscious, so they'll want to be keeping costs down, and doing a counter schedule can be expensive. But I think it's recommended if it's complex. So you've been talking about, someone's got not a career loss, but 3 years, or even if they've got career loss. I think if it's complicated or high value, you want to lay out in exactly the same way your stall for the judge as to why you say, well, that's absolute nonsense. And perhaps your client's keen on settling. If they want to settle ASAP, if doing one could sort of set things out. You've got a claimant who does one and puts an offer in. You've got a respondent who does one, puts an offer in. You can get things settled pretty quickly, in theory.
And when, in terms of, we're approaching this as from the context of the tribunal's natural time frame in terms of proceeding towards a final hearing. Sometimes you have these things for judicial mediation, but when in the timetable do you think you would, from a respondent's perspective, provide a counter schedule?
As I said, it's going to depend on your client's aims. It's going to depend on the context. But I suppose if you're going to do one, I can't see much reason to delay after you've received the schedule of loss. So if I appreciate most people don't, but if we've got the schedule of loss and we're going to do one in due course, or we think there's going to be a judicial mediation, just getting it out there as early as possible, I think, really helps everybody, and helps you to settle. And in the same way that you mentioned before, it helps focus minds. One of the things that often happens is you get to tribunal and we're running a mitigation argument and think, well, it's for us to prove that the claimant has failed to mitigate their loss, and we don't have any job adverts, and it just can be easily overlooked, especially if you're busy. So if you do a schedule of loss early, again, it helps focus the mind. Think, we actually need to get some evidence to show that they could have got a job, and it just makes sure things don't drift, making you think about issues like medical evidence. So if there is a personal injury claim, do you need your own medical evidence? We're going to get a joint expert. It just helps focus the mind.
And how then, do you have any views on how it's best for a respondent to pitch a counter schedule, I should say?
And talking about the boilerplate counter schedule, the boilerplate response, we often do see unrealistic stance to mitigation. They should have got a job within 2 weeks, 100% Polky, 100% contrib, no 0, 0, 0, 0. It's exactly the same problem because it doesn't tell the judge anything. You may have that case. But how's it going to help if you don't really have any prospect? 100%, 0 doesn't tell you anything, doesn't help facilitate settlement, which again might be fine. It might be realistic, but really take a step back and think. Don't just tick a box. Think about, what am I actually trying to achieve with my counter schedule and trying to pitch it. And I agree. I think it's the same exercise. You work out your range, and perhaps you get a couple of notches below the lowest reasonable. Give yourself some wriggle room.
Yes. And you touched on it, I suppose, but is there anything in particular you think needs to go in that we should be mindful of? Yeah,
and I mentioned a number of these things, but reinstatement and re-engagement, don't ignore it if they clearly want it. If it's not going to work, say why. Contributory full, Polky, pension, of course, mitigation and personal injury. So just try and get all of those things in there. And as I say, help settlement. Tells the judge where you are.
And would your approach change whether you were responding to a claimant litigant in person or a represented claimant?
Yeah. So as I said, what we've been discussing so far is when there's a lawyer there, definitely there's more to be gained by doing it with that kind of approach. With the litigant in person, as we discussed before, you can, the claimant gets insight about maybe the people who are thinking about settling it, but it works the same way for a respondent. Ask your client, what's this person like? Are they sensible? Do you think they'll respond well to settlement? And let's say you have a litigant in person, with a claim who reasonably you can analyse it worth 30,000, and they put in a schedule of 1 million. Maybe you just think, what? There is just no prospect here. Let's just focus on the advocacy side of the counter schedule. So you're sort of producing a counter schedule for trial for the judge rather than for the claimant. But as I say, if the litigant in person's sensible and you found that out, pitch something realistic, worth a try.
And so we've been talking about the schedule of loss, and we mentioned how it's often ordered at the first preliminary hearing. But there are a number of other things that are ordered at the preliminary hearing. And so let's think about that first case management PH if we can. Let's flip things, shall we, and think about from the respondent's perspective. What do you need to have in mind? What sort of aims should you have at the first preliminary hearing?
So I think one of the things which is becoming a hot topic, I think some tribunals are trying, because generally speaking with witness statements, it was just the standard was 6 weeks before, 4 weeks before. I think a lot of tribunals, and I think there are some tribunals that are trying to make it very clear they're front loading everything, even with witness statements. So you need to think about that. What's the priority of the client? There's obviously the cost of doing witness statements up front, because it's a very costly thing, but maybe there's a question of settlement as well. If you're incurring a lot of costs, attitudes can harden. But in terms of case prep, doing your witness statements, that's really when I think people really, and witnesses themselves, really start thinking about it. So you create the bundle, do disclosure, got this bundle sitting there, but you sit down and do the witness statements, really get inside the witness's head. I think that really helps you understand your case and how you're going to run it at trial. So it may be better to do it earlier for those reasons. So as I say, doing a witness statement is good for prep. Maybe if there's no chance of settlement, I would be thinking going earlier.
And a lot of tribunals have now taken the practice that if they've got the witness statements ordered at an early stage, in the event that, I haven't actually seen this happen, but I've heard judges mention it, that in the event that a gap appears in the diary and the hearing's ready to go, they'll move you forward, or they'll consider moving you forward. So there is an advantage if you want to get things heard more efficiently. Maybe not from the respondent's perspective. Sometimes they do, sometimes they don't. But certainly from a claimant's perspective, that can be a positive.
And in terms of listing, you always need to be thinking about how long the trial is going to be. So always remember the judge needs time to deliberate, to read and deliver judgment. There's really less than a day for that. So what I always do is I sort of say, what's my instinctive estimate? And then I add a day. With the hearing bundle, always have a descriptive index. You can really make use of that. So I had a trial fairly recently where there were transcripts of a recording, and the index showed which of the recordings were agreed and which of the recordings weren't agreed and why. And it really saved quite a lot of time just trying to figure out how much was going to be in dispute in this case, and it's made a tech judge very happy as the trial was somewhat running away from us. It needs to have obviously clear page numbers, make sure everything's present and legible. One of the things I noticed on cases recently is, unfortunately, when you sometimes have those trial bundles where you put in documents from say an appeal bundle, which we used at the time, sometimes the numbers can overlap with each other and makes it a little bit unclear. So that's something. One thing I think is really important is typed version of hard to read notes. I mean, that's really, really important just for your own counsel. I mean, if you can't read somebody's notes and then suddenly, or somebody else can read them. So if you're for a claimant, but the person who wrote the notes is there and they can read them and you can't, it can really put you at a disadvantage. You need to think about that as depending on whose side you're on to get those kind of notes.
And it is always surprising to me how many companies still to this day have a practice of doing handwritten notes in meetings. And so it's not a problem of the past. it's still something we come across.
Depends on your note taker, I suppose. I once had a judge say, I sort of handed something up, circuit judge. It's not boilerplate, is it, Mr. Singer? Your handwriting. So it's something to keep an eye on. Try to avoid repetition, those dreaded email chains which repeat themselves like in some hellish loop. Really, judges do not like those. Try to have it agreed. You know, a judge does not like having parties arguing over that and 3 supplemental bundles, and whoever's more to blame will probably come off worse in that. So try not to do that. If there's acronyms, if there's sort of explain what they are.
Explaining what they are, absolutely.
And the order is, I think, make sure you have the ACAS certificate, pleadings, orders and directions. Then you have your documents in chronological order. Then an additional chronological section for pay slips, medical record comparators, policies, correspondence, and I think mitigation you can keep separately. Is there anything to add from a claimant's perspective?
Well, I think there's a lot of crossover. I think a lot of those points apply to both parties. Starting with witness statements, I think it's definitely in the claimant's benefit to actually exchange witness statements as soon as possible, and that's because generally speaking, that's when, and it is also in many ways a benefit for the respondent as well, but there'll be more operational challenges for a respondent sometimes, and potentially sometimes they may want to delay things. But from a claimant's perspective, exchange well before the trial. You've got everything down when the case is fresh in your mind, the issues are crystallized hopefully at that point, and you can tell your narrative very, very clearly, and you haven't had time to sort of, or had as much time to forget about some of the key points. The other thing is to think about actually how many witnesses from the claimant's perspective you're actually going to call, because it's very common that we have a scenario where a claimant says, I'm going to call 4 additional witnesses or 5 additional witnesses to me, having not really thought about what that involves or whether they're necessary. And so it's worth including them at this stage when you're at the preliminary hearing, just in case for the purposes of listing, but it's also worth thinking, we'll count them in for now, but I think it's also worth being realistic about, are these people actually going to attend? Because the consequence of whilst it's a double-edged sword in some ways, what you don't want is a hearing that's listed that is too short, and then your justice ends up being delayed because you have to go part heard, but also you don't want to have a hearing that is unnecessarily lengthy, because listing a 7-day hearing is harder than listing a 3-day hearing in terms of how long it will take to get it heard.
I've seen some judges as well be critical of, you know, parties that have said, well, there were going to be 5 witnesses and that they weren't, or vice versa, and it's actually very critical. So, well, we've got I mean, it's rare, but you got the trial length wrong as a result of that. If you don't have a good explanation, that could be seen as unreasonable. So it's definitely worth thinking about it.
It is, and I think this part of the proceedings are really practical issues that have cropped up to some extent that we have to deal with. One of those practical issues being the reality of the tribunal delays that there are at the moment, and the tribunal system, and listing for trial is often quite a frustrating part of the process for a claimant, because quite often you're looking at very far in the future, depending on how long the trial is. And if you've got a complicated case, could be looking into 2028, 2029 for a 10-day hearing, which is crazy. But this sort of leads me to an example of something that I experienced a few weeks ago that I think it gives us some encouragement to think about how we can be a bit more creative about having cases heard. My encouragement would be to claimants to be open-minded. So I had a whistleblowing claim recently that we listed where it was going to be for at least 10 days and not heard until mid-2028. But the judge offered the parties the alternative of splitting the hearing up, so we could have 4 days just dealing with whether or not the claimant had made protected disclosures,
right,
and then subsequent hearing only a month or 2 later, another 4 or 5 days to deal with whether or not they suffered detriment as a result of any disclosures they're able to prove they actually made. So sort of a bit more of a creative way of dealing with it, and that meant that it was only a year until the final hearing, so by no means particularly lengthy in the context of the tribunal. we'll see how that works. But I think being open-minded about how a case can be run from a claim perspective, if there is an intention to get it heard sooner rather than later, is worth thinking about.
Okay. So let's look at those very important people, witnesses. Do you have any tips on how a claimant might choose their witnesses?
Well, often a claimant will only have themselves.
Yeah.
So they won't be choosing anyone. Often it will just be them. But where they do have to choose someone, you might see, and quite often we do see, the claimant's partner or family member called. They can be a useful witness for certain particular aspects of a case. So particularly on something like disability, they can give evidence as to the substantial adverse impact on their day-to-day activities, the reality of how their condition affects them. They can also give some support as to contemporaneous accounts from the claimant of sort of the contested issues, what they said happened at the time to them.
Yes.
That can be helpful sometimes. There are also some scenarios where they might only be able to speak to remedy because they weren't involved in the workplace. Sometimes you have husbands and wives who work together. That's a different scenario. But think about what the witness is there to do, and think about whether or not they can actually assist. The reality is usually it's the respondent who has more witnesses. But that leads me to another point, which is from the claimant's perspective, there is the opportunity to apply for a witness order. This is a dangerous tactic, but it can be an effective tactic. If you apply for a witness order, someone was specifically involved in an incident and has evidence to give about it. You could put the respondent under a significant amount of pressure by obtaining a witness order from a witness they don't want to be called. However, the witness hasn't come voluntarily, and so you've got to be prepared for them to not give evidence that is necessarily supportive of the claim. But it's something to consider.
Absolutely.
Definitely. And what about from the respondents? Any witnesses that you would avoid or you think need to be called? What do you need to consider?
Okay, so if there's an exercise of a discretion, sort of a decision maker, that's the most important thing. You have to consider carefully whether you need anyone else, if that's really all it's about. In unfair dismissal cases, we all know, as a general rule, dismissing officer, appeal officer are the people we call, but actually the investigating officer can be quite helpful. So if, for example, it's a very technical or complicated area, sometimes the investigating officer can give that technical information, which makes sure that everyone understands what these things were and can sort of shed some light on why the dismissing officer and appeal officer made their decisions. Perhaps if the dismissing officer's a bit weak, the investigating officer, although they didn't make the decision, can help bolster them. This can also really help if you're likely to lose and your dismissal and appeal officer are weak. With the investigating officer, you can get some useful facts out to help with Polkey.
Yeah, exactly.
And wrongful dismissal claim, of course, you're looking at actually what happened, so it may benefit from calling them. In discrimination cases, everyone who is impugned, everyone who has an allegation against them really should be called, even if they're sort of bit part players, because the key is what motivated them. So it can often be the case if there's a couple of allegations which sort of everyone's forgotten about, forget to call those witnesses. It's not ideal. If you lose on those and you've got two findings of discrimination, there can be inferences drawn in other parts of the case. So really important to make sure you deal with all of them. Don't assume that lower grade staff will make worse witnesses. Actually, the reverse can be true. And witnesses who can only speak to one or two issues can be very, very useful. Have these little short witness statements, very hard to cross-examine on, and also sort of, again, could be overlooked, and you've sort of got those witnesses in, got some helpful facts out there. But, be selective. Don't just really think about who you're going to call. So from a tactical perspective, of course, asking yourself may sound obvious, but why are you calling them? What are they needed to cover? So you might want to have a checklist, or which allegation they are. It's really complicated. Just having that checklist to go through. There's the allegation, there's the witness, here's what they are to prove. Try to avoid jargon. Tribunals don't know the case. Counsel, when they first see it, don't know the case. And if you can't understand it on its own terms, then there's probably something not so good in the witness statement or witness. And don't just get the witness to repeat the contents of minutes of meetings. You can use the witness to pull out key points and have a clear narrative in their statement. I mentioned that psychological experiment earlier, applies the same. Try to use the witness's own words as well. It was in the
old days,
the bad old days. So you went around
before
with it before your time. You might
before
jump
my
at me, aren't you?
time,
But
yeah.
remember, we had to read witness statements out, and I remember colloquially every witness statement. One of my these colloquially, and this witness going and Berkeley. It's like the judges sitting there saying, "So what?" Not great. And I appreciate when you're not reading the statement out, it doesn't matter so much, but they're going to be cross-examined on it, so it's got to be in their own words.
You still have people being cross-examined on the content of their statement and it being clear that they wouldn't have used the particular line that's in there. So I think it's a fair point, and it can be embarrassing.
And one very important tip is, and I'm sure this applies to claimants and responders, get the comments from the witnesses, send them the statement and say, can I have some comments on the statement, please? If you've got lots, so say some of my solicitors do, is really helpful. You get a table and you've got paragraphs on one side and then the witnesses there, so you can see which witnesses are commenting on which paragraph. And it's just so helpful, firstly for your case prep, but also so the witnesses get their head in the game, so they know what if you're for a respondent, you know what the claimant's saying, and you've got an idea of what their issues are, and it just gets your witnesses' head in the game. Just a few general things. Make sure your witnesses check again the accuracy of the statement. Just make sure you're checking for inconsistencies between the statement and documents, between your witnesses. Look, ultimately, the witnesses have to tell the truth, the whole truth, and nothing but the truth, and it's there. But these things have to be checked carefully. And just get the witnesses, just really get them to read. Often they get to conference and it's a few days before and they haven't read their statements. It's so important. And I'm sure you do it and they ignore you, but just make sure that the witness reads the documents as well. So we're coming, sort of drawing to a close, but just the final handover, passing the baton. What about instructing us? Do you have any tips as to
what's helpful,
to how we can be instructed to have help?
I think what is helpful is a brief summary, but repeating the ET1 it isn't necessary. That we'll obviously always be reading that ourselves and reviewing that. It's about the key issues or dispute and anything that we need to know specifically. If there's anything, sometimes it may be that there is something that just requires a telephone conversation, and that's something that's always useful to have. It may just not be as clear from a written brief as it is from a telephone call. Important to know, obviously, who is coming to the hearing, who the people who you're going to see when you're there, and you'll be able to discuss further any other points with them then, when you need to meet them, obviously. And then I think always, but depending on whether, well, in fact, for both claimant and respondent, up until the hearing, of course, the prospect of settlement is still on the table. And so it's always really helpful to know, is there in fact still a prospect of settlement, and what do you think of the case? Do you think this is a case that it would be worth settling? Do you think that there are witnesses who we need to be particularly cautious of, or think they'll be a really good witness, and so we might want to try and promote what they say in our submissions at some point? Just have that in mind. Is there any information that needs to be passed on to the client, because the client's obviously going to be there, ideally? And are there any other concerns that shouldn't be shared with the witnesses, that should be in our minds, that we should have some awareness of, and just be managing that as well? So those are all sort of general points that are always really helpful to have in our minds, and to be aware of, that might not ordinarily be included in a set of instructions. And so sometimes I know from a respondent's perspective and from a claimant's perspective, solicitors will do sort of prospects documents which they send to their clients. It's always helpful to see those, and then get a sense of, okay, this is what the client's been told, and this is where the solicitors see the case. It probably isn't that dissimilar from the respondent, but is there anything else that you think might be worth emphasising in a respondent brief.
Yeah, it's slightly different with the respondent. So you probably have a number of different witnesses. So is there any internal politics you have to be aware of, personality clashes? Is there anything we need to know to manage the client relationship? Pick up the phone if it's sensitive. And just when and how a bundle is going to the tribunal. So obviously the respondent just has carriages of that, just something small to know. And I agree on everything you said about settlement prospects. I think with a respondent, the bigger picture can be important. So is there something we need to know about? Is there an aim here, for example, deterring a union of bringing more claims? Or is there something in the background we need to know about the bigger picture? And in terms of the conference, I think after the exchange of witness statements, perhaps a week or two out is quite a good time to meet the witnesses. So you've got the witness statements. It's close enough to trial so that they're not going to forget everything, just to make sure their heads are in the game for the trial, but you don't want it too far out. And finally, just a couple of extra things, electronic bundles. We're seeing those more and more, obviously, if we're doing it remotely. It's quite frustrating sometimes if you've tabbed up a bundle and then suddenly 15 documents are added throughout, which knocks out all of the pagination. I appreciate sometimes it's not possible, but just always be thinking about how the electronic bundles might affect counsel's preparation. Sometimes you can just add documents to the end of the bundle. I appreciate there's an anxiety about judges saying, well, it's not in order and all that. And contradicts something I said earlier about how you produce bundles, but sometimes if everyone's prepared a really complicated case over a number of weeks and then some extra disclosure throwing everyone's preparation out, including the other sides, may not actually be helpful. Yeah, and I think that's it. Unless you had anything else to add. I don't know if there have been any questions. I haven't received any in my inbox.
No, I haven't. No, I think that's a sort of summary of where we are in terms of getting up to the door of the tribunal, so to speak, and the sort of practical tips that we have. But no, I don't have anything further to add. If we don't have any questions, then I think we've been. Do we have any? No.
No.
Brilliant. Okay.
Okay. So, thank you very much for attending. And if there are any questions, I say feel free to email, or if you're watching a recording, feel free to email to events@42br.com. The recording will be available on the website and YouTube channel shortly, and we're always absolutely grateful for any feedback. Spoiler alert, the next session will be taking place on Thursday, the 11th of November. That's Thursday, the 11th of November. We have Laura Robinson and Matthew Tim talking about philosophical belief, how to deal with conflicting beliefs in the workplace. So please sign up for our next seminar. We have seminars and webinars regularly throughout the year. So please sign up to all of those. But thank you very much. And
thank you. And goodbye. Thank you.